We now come to new clause 4, which has already been debated. Pete Wishart to move formally. The question. New clause 5. Oh, we've done clause 4. Oh, right. Oh, apologies. The new. We now come to new clause 5. With which it will be convenient to consider new clause 13. I call Pete Wishart.
Thank you very much, Dame Siobhan, and I trust everybody enjoyed their 5-course banquet that we had within the 20 minutes available to us for lunch. And apologies if it seemed to be me that seemed to be unnecessarily detaining the committee and depriving them of a good and solid lunch. We'll make sure that doesn't happen again, Dame Siobhan. I think it was with a gasp of astonishment that we learned of this government's intention to change the nationality good character requirement guidance. And it was something that just came totally out of the blue, and I think we're all still reeling a little bit about what this involves and what's at stake. What it does is establish a new standard that individuals who previously entered the UK illegally or without valid entry clearance, particularly what's described as a dangerous journey, will now be refused citizenship. This is a huge department from previous practice, where illegal entry was typically considered a barrier to citizenship only if it had occurred in the past 10 years. Now, regardless of how long a person has lived in the UK, their mode of entry could be used to deny them the right to naturalise. This policy has been implemented without prior consultation or parliamentary scrutiny. It's going to get a little bit this afternoon, but it's only because we brought that to this committee, raising serious concerns about its fairness and its legality. The majority of refugees arrive in the UK through irregular routes, as safe and legal pathways remain extremely limited, as we learned from the previous debates. By effectively barring these individuals from citizenship, this policy risks permanently disenfranchising those who sought protection in the UK and who have built their lives here. Now, we've already heard from the UNHRC, and they've written to this committee. And what they said is this decision to deny citizenship based on mode of entry contradicts the UK's commitment under international law, particularly Article 31 of the 1951 Refugee Convention. This article's non-penalisation clause states that the contracting state shall not impose penalties on refugees who, and I quote from the article, who, coming directly from a territory where their life or freedom was threatened in the sense of Article 1, enter or are present in their territory without authorisation, provided they present themselves without delay to the authorities and show good cause for the illegal entry or presence. Dame Siobhan, the denial of citizenship based on how someone arrived in the UK is a clear penalty, contrary to the Convention. Now, the UNHCR previously highlighted in its legal observation on the Illegal Migration Bill 2023 that restricting access to citizenship under Section 31 to 35 of the Act would amount to a penalty under 31 of the Refugee Convention, thereby violating its provisions. It also stated these restrictions conflicted with Article 34 of the Refugee Convention and Article 32 of the 1954 Convention of Statelessness, both of which require states to facilitate the assimilation and naturalisation of refugees and stateless individuals wherever possible. Despite the proposal repeal of these provisions, the updated nationality good character requirement guidance issued in February 2025 appears to reintroduce similar barriers, further restricting pathways to citizenship for those affected. In addition, this policy changes is likely to deter many from applying for citizenship altogether, given the high costs involved and the lack of an appeal process in case of refusal. So even if the guidance states that exception may be made, which I'm pretty certain is what the Minister is going to tell me, even those who would be likely to obtain citizenship due to their personal circumstances will be deterred from applying. Now, currently, a naturalisation application costs £1,605 with an expected increase to £1,685. This financial burden, combined with the uncertainty surrounding the application process, creates significant barriers for refugees and stateless persons who would otherwise seek to integrate fully into British society. And the implications of this policy go beyond individual applicants. Citizenship is a key factor in social integration, providing security, stability and full participation in civic life, including the right to vote in general elections. Without access to naturalisation, many individuals who have lived, worked and contributed to the UK for years, if not decades, will remain in a precarious status. While the Home Office guidance allows for some discretion in decision-making, it provides no real criteria on how this discretion will be applied. The lack of transparency makes the process unpredictable and risks creating a system where citizenship decisions are inconsistent or arbitrary. These changes also highlight the broader issue of immigration law being shaped through administrative guidance rather than through democratic scrutiny, the role of us as parliamentarians in this House. By changing the interpretations of the statutory good character requirement without parliamentary oversight, the Home Office has effectively reinstated elements of the Illegal Migration Act, provisions that were meant to be scrapped through the Border Security, Asylum and Immigration Bill. This lack of accountability is deeply concerning. Now, granting citizenship, Dame Siobhan, is a key step in ending an individual status as a refugee or stateless person. It also benefits the host country by fostering economic, social and cultural integration while promoting social cohesion. Restricting access to citizenship undermines these objectives. That is why I brought this amendment here today, and I beg to move. Thank you.
The question is that new clause 5 be read a second time. Matt Vickers.
The new clauses would require the Secretary of State to change current Home Office guidance stating that people who enter the UK illegally, regardless of how long ago, will normally be refused citizenship. It states that illegal entry, i.e. breaking into this country, should be disregarded as a factor for the purposes of assessing whether a person applying for British citizenship meets the good character requirement. Effectively, both the Liberal Democrats and the SNP want to ensure that entering this country illegally is not a bar to gaining citizenship. British citizenship is a huge honour and privilege, and the benefits come with it have attached costs. Can honourable members see what a pull factor this would create for making dangerous channel crossings in small boats? There is nothing compassionate about allowing small boat crossings to continue, and in fact this would do nothing but encourage more. The Labour government are already repealing provisions in our Illegal Migration Act that prevented illegal migrants from getting citizenship. It seems the SNP, the Liberal Democrats and the Labour government are all in agreement that illegal migrants should get British citizenship. Do the SNP and the Liberal Democrats agree with the Prime Minister that British citizenship is not a pull factor for illegal immigrants? If people believe that crossing in a small boat will not only ensure they're able to stay, but that they can stay forevermore with all the attached benefits of British citizenship, they will continue to come in ever-increasing numbers. Even the government's own Border Security Commander has said we can't smash the gangs without a deterrent. British citizenship and all the associated benefits would see us place an incentive for making that small boat crossing, inducing people to feed the model of these evil people smuggling gangs. The Conservative Party believe British citizenship is a privilege, not a right, and certainly not a reward for illegally crossing the Channel. We do not support this measure.
Can I see Sarah Ball?
Thank you, Dame. I just wanted to put on record again, really, the importance of the rule of law, because what this clause is essentially getting at is allowing rights when you've entered into the country illegally. And the rule of law and compliance with the law is absolutely fundamental within our system. And I can't really accept the premise that acting illegally is waived or permitted. We are a country of fairness, and that has to be fairness and equality under the law. And this provision really flies in the face of that equality. If you make an exception here, no matter how desperate, you set a dangerous precedent. And it is a privilege, as my honourable friend has said, to have British citizenship, and that so many abide by this. And I think having a system like that for those who are actually trying to enter into the country via legal routes really fundamentally undermines that. So I think we have to be incredibly careful in how we proceed with these sort of elements, and anything that is illegal, I mean, the clue is really in the name. Thank you.
Will Forster.
Thank you, Dame Siobhan. I'm happy to support my honourable friend, the member for Perth and Kinross's new clause. I'm also promoting new clause 13, which does effectively the same thing. I think this is about fairness and reasonableness, and ensuring that effectively no refugee or asylum seeker can get citizenship, I don't think is reasonable. Refugees would forever become second-class citizens if we allow this to go ahead. And I'm really concerned that this would deepen divisions within society by disenfranchising our newest constituents and residents. The refugees that I've spoken to in my constituency of Woking are so proud when they get citizenship. They are so proud of it, and it encourages that integration. And I think effectively banning anyone, which is what this amounts to, is wrong. So I'm happy to support both new clauses. Thank you.
Thank you, Dame Siobhan.
To quote my right honourable friend, the member for North West Essex, British citizenship is, or at least it should be, a privilege to be earned, not an automatic right. Citizenship should be available only to those who have made both a commitment and a contribution to the United Kingdom. For example, it should be a fundamental principle of our system that people who come to this country do not cost the public purse more than they contribute to it. It should also be a fundamental principle of our system that those who seek to harm this country, to break its laws, to undermine what we hold to be fair and right, should never be able to become British citizens. To state something so obvious that it sounds almost silly, those who have come to this country illegally have broken the law. What the Liberal Democrats and the Scottish National Party are proposing is that we ignore that fact. As my honourable friend, the member for South Northamptonshire, has just said, how can we possibly say that law-breaking should not be considered when assessing whether someone is of good character? It seems to me outrageous and unfair and completely against what we understand to be the wishes of the public, that anyone who has broken the law should have a blind eye turned to that when it comes to determining their character, and thus whether they should become a fellow citizen of this great country. Separately and additionally, we would also like to state that we feel the time frame the Honourable Member for Perth and Kinrossshire has suggested in his amendment is far too short. In line with our party's wider policy, we feel that 5 years is not enough time to qualify a person for indefinite leave to remain. Immigration, as we are all well aware, was at well over 1 million people per year in 2022, 23 and 24, and net migration was at or expected to be at least 850,000 people for each of those years. If we accept that the immigration policy of the past few years was a mistake, then we should make every effort to reverse the long-term consequences. That is why the Conservative Party is advocating that the qualifying period for ILR should be extended to 10 years, not the 5 years given here. Finally, I would like to return to the point I made earlier about Scotland, the Scottish National Party, and the proof of their compassion as compared with their words, because the Honourable Member for Perth and Kinrossshire shook his head when I was speaking about the number of asylum seekers and where they are located. The latest data to be released for this is for December 2024. As I read it, there are 1,421 asylum seekers in hotels in Scotland, compared with 36,658 in the rest of the country, and 4,262 asylum seekers in dispersed accommodation, compared with 61,445 across the rest of Britain. Those are, I appreciate, challenging mental maths. So I will tell you that means Scotland houses only 5% of this country's asylum seekers currently accommodated by the state. So it is underweight relative to population and dramatically underweight relative to size. Given everything the Honourable Member for Perth and Kinrossshire has said that he and his party, the Scottish National Party, stands for, wouldn't we expect the opposite to be true, that Scotland will be pulling more of its weight here rather than less?
Call the Minister. Thank you, Dame Siobhan, and I'm grateful for the opportunity to speak in response to the debate and on new clause 5 and new clause 13. I want to just clarify a few points in relation to this debate, because
There are already rules that can prevent those arriving illegally from gaining citizenship. The Home Secretary in February further strengthened measures to make it clear that anyone who enters the UK illegally, including small boat arrivals, faces having a British citizenship application refused. This change does apply now to anyone who entered the UK illegally, or those that arrived without a required valid entry clearance or electronic valid authorisation, having made a dangerous journey, regardless of the time that has passed since they entered the UK. Citizenship applications will continue to be considered on a case-by-case basis, and I will say a little bit more about that. It's also the case that the previous government's Legal Migration Act was never operationalised or enacted. We have always kept citizenship policy under close review, and we continue to do so. And the guidance builds on statutory requirements to be eligible for naturalisation as a British citizen, such as requiring the person to have become settled alongside criminality checks. Now, the amendments that we've got tabled today, new clause 5, would also seek to create a right to naturalisation for refugees who are settled and have lived in the UK for 5 years. It's important to make the point that no one has the right to naturalise. Citizenship is a privilege, and an applicant must meet the statutory requirements, including whether that person is of good character. Many people applying for naturalisation cannot meet the statutory requirements until they have lived in the UK for a minimum of 6 years. This amendment would see a faster and more generous approach to citizenship for refugees than others applying for citizenship, and it would lead to people who would not meet the good character requirement because of their criminality or other behaviour being granted British citizenship. I think it's important also to make the point that we do believe that rules must be respected and enforced for the asylum and immigration system to work. And that is part of the reason for making this change to the good character guidance, in immediately strengthening measures to ensure that anyone who enters the UK illegally faces having a British citizenship refused. But it can also be the case, and we have this in the guidance, that it will remain on a case-by-case basis, considering factors such as where, for example, someone has been trafficked here through modern slavery. And this is important in order to have both a robust and a fair approach. And we continue to assess citizenship applications on a case-by-case basis in line with the UK's obligations under domestic and international law. When it comes to a good character assessment, it is important that consideration is given to all aspects of a person's character, both negative factors such as criminality, immigration law breaches and deception, and positive factors such as the contributions that a person is making to our society. So I do hope that for the reasons that I've outlined, that honourable members, I would politely request they may consider withdrawing their amendments, and that we continue this conversation in relation to citizenship, which I'm sure will be one that this House will return to.
Thank you, Dame Siobhan. I remember saying at the start of my second reading speech, when we looked at this for the first time, that this government were just pretty much carrying on in the vein and the approach of the Conservatives. And I think doing something like this, something so all-encompassing and denying, is probably worse than what the Conservatives would ever produce. They didn't conceive anything like this. They're capable of having a warped imagination that produced the Rwanda bill, but they didn't even come close to something like this. And as well as a privilege, surely British citizenship should be available. And what they are doing with the change in this good character reference is denying all asylum seekers and refugees the slightest opportunity to become a British citizen, except in narrowly defined circumstances as the Minister pointed out. And that goes with all the things to do with cohesion, about giving people opportunities. I thought that was the British spirit. Now, I'm a British citizen. It's not a particular definition I want to hold on to for much longer, but I am a British citizenship. And to me, it just strikes me as it's just not British to deny a whole swathe of people in this country the right to achieve that status.
Thank you for giving way. I wonder if he realises how ironic this is to be lecturing us on British citizenship when he doesn't particularly want his himself.
I'm sure the honourable gentleman and I will be able to have the opportunity to discuss these issues in the future of this Parliament, and I very much look forward to that. But I didn't hear anything from the Minister at all about anything to do with the UNHRC's quite stern rebuke to this government and the written evidence that they provided to this. Their concerns that this is coaching horses through the UK government's commitments to certain sections of the Act. And I'd like to hear that, just to see if she's even slightly embarrassed about what has been presented to them. This is a nasty, pernicious move by this government, and it's something that's not particularly in the spirit of what I think they're even trying to achieve with this bill. It's a continuation of the ethos of the previous Conservative government. It even introduces through the back door certain aspects of the Illegal Migration Act that we're very keen to move on to. So I really hope that the government reconsider this, and I will certainly be testing this committee with a vote on this very amendment. Thank you, Mr. McDonald.
New clause 5 proposed is on the amendment paper. The question is that the clause be read a second time. As many are of that opinion, say aye. Aye. To the contrary, no. No. Aye. No. No. Division. No.
Division's room 9.
Lock the doors.
Okay, Sarah Ball? No. Jade Botterill?
No.
Dame Angela Eagle?
No.
Will Forster?
Aye.
Becky Gittins?
No.
Tom Hayes?
No.
Katie Lamb?
No.
Martin McCluskey?
No.
Seema Malhotra?
No.
Margaret Mullane?
No.
Chris Murray?
No.
Kenneth Stevenson?
No.
Mike Tapp?
No.
Matt Vickers?
No.
Joe White?
No.
And Pete Wishart?
The ayes were 2 and the noes were 14, so the noes have it, unlock. We now come to new clause 6, which was debated with new clause 1. Does the member want to move formally? Mr. Forrester?
So, I would like to move formally. Sorry, the different numbers than I was expecting.
Additional safe and legal routes.
The question is that clause 6 be read a second time. As many are of that opinion, say aye.
Aye.
To the contrary, no.
No. No. No. No. No. No.
Division.
Division's room 9.
Lock the doors.
Sarah Ball?
No.
Jade Botterill?
No.
Dame Angela Eagle?
No.
Will Forster?
Aye.
Becky Gittins?
No.
Tom Hayes?
No.
Katie Lamb?
No.
Martin McCluskey?
No.
Seema Malhotra?
No.
Margaret Mullane?
No.
Chris Murray?
No.
Kenneth Stevenson?
No.
Mike Tapp?
No.
Matt Vickers?
No.
Joe White?
No.
And Pete Wishart?
The question is that new clause 6 to be read a second time. Oh, sorry. The ayes were 2, the noes were 14. I think the noes have it, unlock. We now come to new clause 7, which was debated with Amendment 1. Will Forster to move formally?
Move.
Duty to meet the Director of Europol.
The question is that new clause 7 be read a second time. As many are of that opinion, say aye.
Aye. Aye.
To the contrary, no.
No.
No. I don't hear the overwhelming desire for a vote on that vote, so I declare that the noes have it, the noes have it. We now come to new clause 8, with which it will be convenient to debate new clauses 9 and 10. I call Will Forster to move new clause 8.
Move formally. May I speak now? Yeah. Thank you. I will be relatively brief. So we've got 3 new clauses about Europol here that the Liberal Democrats and I think are vital to make sure this bill goes further and is more effective than originally envisaged. Cross-border cooperation is key for reducing small boat crossings, something that the former government made harder for us as a country to do. But as I said, this bill misses that opportunity to tackle this better. We believe that this government should strive for greater cross-border cooperation, including working with Europol, and including that as part of the legislation seems a sensible step for us. And on that, I will pass on for any questions or comments.
Duty to establish a joint task force with Europol.
The question is that new clause 8 be read a second time. Anybody wish to enter the debate?
Yep.
Matt Vickers.
Liberal Democrat new clauses 8, 9 and 10 attempt to establish a joint task force with Europol and provide annual reports to Parliament to reduce levels of people smuggling and human trafficking. Most governments accept that international partnerships and cross-border cooperation have a role to play in solving this problem, but these amendments could restrict the government's ability to negotiate in this whilst creating a cost by way of needing to provide further adequate resources to enhance this partnership and participation, and creates a responsibility to create yet another report. The National Crime Agency has said no country has ever stopped people trafficking upstream in foreign countries. The Australians have done it, but that was with a deportation scheme. Why do honourable members not think a strong deterrent that people who arrive in this country illegally will not be able to stay would not be more effective in stopping people smuggling? I realise the Lib Dems seem to think that Europe has the answer to all of the world's problems, but surely even they must realise the need for a deterrent rather than an incentive. In fact, as Europe reconsiders its approach to immigration, looking at what it can do to deter illegal entries, it's even more important that we do the same rather than becoming the soft touch of Europe.
Katie Lamb.
Thank you, Chair. In line with comments that other members on the government benches have made on other points about this bill, it seems to us completely unnecessary that these clauses should be included on the face of the bill. Exactly as my honourable friend, the member for Stockton West, has just said, they do not seem to us appropriate for primary legislation and seem more likely to constrain rather than empower the Home Secretary and her ministers in the difficult job they have of securing the border.
Minister, oh, sorry, I apologise, the Minister. Becky Griffiths.
Thank you, Dame Siobhan. It's a pleasure to serve under your chairship, and I'll keep my comments brief. I read these new clauses from the honourable member with interest and understand the important point that has been raised, I think, on both sides around the importance of working internationally on this. And I suppose my question to him would be, does he not already think that an international outlook in tackling the issues that we have here, which is the sole purpose of the bill, has already been exercised, not least with December of last year, we agreed the Calais Group Priority Plan with our near neighbours and the Joint Action Plan on Migration with Germany. In November of last year, we had the landmark security agreement with Iraq, and additionally, the well-established relationship we already have with our counterparts in France to work closely to prevent the dangerous crossings and reduce the risk to life at sea. So, on the whole, I understand we've talked a lot about cause and effect, and I can really see the intention behind the new clauses, but I question their necessity, as well as some of the suggestions made about the intention of the government, who have really shown a pragmatic look about how we deter those crossings. Thank you, Chair.
Tom Hayes.
Thanks. Just very briefly, I do wonder whether the SNP and the Liberal Democrats are experiencing post-traumatic stress disorder. And I mean that in two senses. The first is that they query whether this is a government committed to international human rights when we have a government which has time and again shown that it is. But I understand the concern about that given what has gone before. And I think with this situation where they're trying to prescribe in primary legislation the foreign affairs of this government and the regularity with which it meets international organisations, I wonder too whether they're experiencing some stress, post-traumatic stress disorder, because they know with the previous government that it was the resort of the Conservatives to stick two fingers up to our international partners and international agencies. So I hope they will withdraw this amendment, because they should feel reassured that with this government they have a respect for human rights, international law, and working with our international partners and agencies.
Can I call the Minister?
Thank you very much, Dame Siobhan. I hope you too enjoyed a long and languid lunch after the way that we overshot this morning's session. This group of new clauses introduces requirements for the Secretary of State in primary legislation to put in place arrangements for closer cooperation with Europol, which includes seeking the establishment of a joint task force providing adequate resources for participation in Europol's anti-trafficking operations and publication of an annual report. And I think that very few of us, Dame Siobhan, would quibble with what I suspect the output of such clauses is seeking to bring about. But I do want to quibble with the means by which the Honourable Gentleman, the member for Woking, has decided upon to try to bring them about, and that is putting things on the face of a primary piece of legislation which can't easily be changed or moved or shifted about, which actually create more issues and less flexibility than I'm sure what he is seeking to achieve. And I suspect that what he's doing with these new clauses is hanging the requirements that they would put the Secretary of State under onto the bill as a hook to have a debate about how the government is going to be cooperating with international agencies, law enforcement agencies, rather than actually really saying that we should be doing what that his new clauses suggest we should be doing in quite a rigid way. And I want to see if I can reassure him that we actually are doing what I think he wants us to do in the new clauses, but in a much more flexible way, in a way that can be changed very quickly because it's not stuck in a piece of primary legislation. I think we discussed it on day one of the committee as well. The UK has a strong existing relationship with Europol, including significant permanent presence there in the agency's headquarters in The Hague. UK law enforcement agencies already collaborate with international partners through Europol-supported operations. The allocation of resources for participation is an operational decision for law enforcement agencies, and certainly not one which ought to be put on the face of primary legislation. There's a regular interaction with Europol on both operational and strategic matters between Europol and this government and the Home Office, including at the most senior levels. The Home Office will continue to work with a range of international bodies, not only Europol, in other words, Frontex, operational work with many of the law enforcement agencies throughout different European countries and beyond, for example, to deliver the government's border security objectives, because we recognise that border security isn't just one's own border, but it's quite often weaknesses in others' borders along the traveller routes and along the migratory routes that causes weaknesses. Indeed, sometimes visa regimes in countries can cause problems in the UK. For example, the sudden appearance of large numbers of Vietnamese who clearly haven't walked from Vietnam on small boats last year, particularly caused by changes in visa requirements that had happened in other countries. So these things are interrelated. Fighting organised immigration crime is an interrelated operational and diplomatic and political matter, which this government is doing a great deal of work to try to strengthen and make more effective. The UK regularly participates in operational task forces with EU partners, and it's inappropriate to place a statutory requirement to seek to establish a joint task force on the face of a piece of legislation which would force us to have a joint task force whether we wanted one or not, and whether it would do any good or not, thereby in that case diverting precious resources to somewhere where they weren't operationally needed. So I hope the honourable gentleman understands the points I'm getting at. The Border Security Commander will provide an annual report to Parliament setting out their views on the performance of the border security system as it develops. Europol is an individual agency among many through which the UK law enforcement collaborates to achieve the Border Security Commander's objective, and I hope that the honourable gentleman will accept my comments on his 3 new clauses in the spirit in which they were intended, which is, we know what he means, we think we've got a better way of bringing it about in a far more flexible way than his new clauses do. If he accepts that argument, I certainly hope he'll withdraw.
Paul Forster.
Thank you. I don't quite get the reasoning that we don't need this amendment to work with Europol because we already work with Europol. This amendment is about empowering Parliament and making the Executive Act, which is what we're keen to do. I will not withdraw the amendments, but I will not push it to a vote either.
Is everyone content the new clause to be withdrawn? Yes. New clause by me withdrawn. We now come to clause 9, which has just been debated. Will Forster to move formally?
I will take all 3 of them together if I may, and I'm happy to withdraw the lot.
I'm not sure I can do
You
that.
can't? Oh, okay. Move formally.
Yeah.
Participation in Europol's anti-trafficking operations.
The question is that new clause 9 be read a second time, as many are of that opinion say aye. Oh, yes, I apologise, yes, you're not moving it. Is it by leave of the committee that the amendment be withdrawn? Aye. Okay. We now come to new clause 10, which the member also wishes to withdraw by leave of the committee. Is that agreeable? Aye. We now come to new clause 11, which the member also did not wish to take to a vote.
No, sorry, that is different to Europol, if I may, Dame Siobhan. Move formally. So this clause is about allowing asylum seekers to work, and I want to take the 3 separate clauses about Europol in one item, if I may. This is a common thing that is just raised with a lot of people, that this country discourages asylum seekers from working. And it seems that it's viewed as tough on them. But what it does is it encourages a welfare bill, and which is not acceptable. We do have a lot of research on this from the Lift the Ban Coalition. And several years ago, they said that actually the fiscal gains of this would be significant. They said originally it would be £97.8 million a year. That figure was later revised up to £108.8 million. I think this would encourage work, it would lower the benefits to the taxpayer and ensure integration, ensure better integration. I will give way.
Thank you. I think one more member giving way. Doesn't he agree that what's causing that huge bill is not that people can't work, is that they're waiting for a decision and they're stuck on a backlog, and if we could get the decision made, then it would obviate this discussion completely?
Thank you. I do agree with that. The system has been broken by the previous government. It's one of the very few things that we completely agree on. I think the issue is, but when we know the system is broken, you leave people stuck in limbo. And until the system has been fixed, let's enable them to work. Let's let them use their skills to benefit our constituencies. If we could have a quick decision in a matter of weeks, there would be no need for this. But we know that's not going to happen. That has been consistently failed to be implemented. In the meantime, let's encourage asylum seekers to work for themselves, their benefit, for their benefit of their families, and the benefit of our constituents. Thank you.
Removal of restrictions on asylum seekers engaging in employment. The question is that New Clause 11 be read a second time. Matt Wickett.
Thank you, Dame Siobhan. Liberal Democrat New Clause 11 attempts to remove the restrictions on asylum seekers engaging in employment. This is yet another inducement for making that perilous journey. It will be another selling point for those people smuggling gangs as they make their pitch with the aim to profit from the peril of others. This clause, coupled with the last, seem to mark out a marketing plan for those evil, immoral people smuggling gangs. Successive governments have maintained that easing work restrictions could draw asylum seekers to the UK because they believe that the reception conditions are more favourable. It creates a huge potential for an increase in applications from economic migrants whose primary motivation for coming to the UK is to benefit from work opportunities rather than to seek safety. Do the Liberal Democrats not agree that this will act as a pull factor for migrants all over the world to come to the UK? Do the Liberal Democrats understand the impact such a policy would have on other departments such as DWP and the HMRC? If the Liberal Democrats are worried about skills shortages, what plans do they have to get the 9 million economically inactive people already in the UK into these roles? And what thoughts have the Liberal Democrats put into this measure and the legal issues it may introduce with employee rights and further challenges that will give the Home Office in swiftly removing those here illegally to the country of origin?
Katie Lamb.
Thank you, Chair. When we were in evidence for this bill, Professor Brian Bell, who chairs the Migration Advisory Committee, spoke about what he sees as the incentives for people to come over here from France, which is, of course, a safe country. He spoke of the strong economic incentives to come to the UK and the challenge this poses for any government because, as he said, these incentives are not necessarily ones it would benefit us to remove. The unemployment rate is 7.8% in France, he said, and 4.4% in the UK. The gap is slightly larger for young people than for the population as a whole. I'm sure the government would not want to change that incentive, although the French probably would. If you have a buoyant economy relative to your neighbour, at least in the labour market, that is an incentive. He went on to say that there are some things we could do that might help, like better enforcement of our labour laws that make it more difficult for people to work illegally. But what the Honourable Member for Woking and the Liberal Democrat Party are proposing here is exactly the opposite of what I thought Professor Bell was saying we should do. Allowing asylum seekers to work before their claims are approved will make it easier for people to come here illegally and make money. And so it will increase the economic incentive for people to come, which we have heard is a, or perhaps the, primary pull for people making these life-threatening journeys across the Channel in the hands of organised criminal gangs. We consider this to be deeply wrong, counter to the aim of everything we are trying to achieve here in securing the border against illegal migration, unfair and immoral.
Mike Tapp.
Rare moment of general agreement with the members for Stockton West and Weald of Kent. So we'll savour this. We'll savour this moment. I'll make some very quick points on this. It does create an additional pull factor for those seeking to travel. We don't know who is a genuine asylum seeker until their claims have been processed, and this amendment that he makes may well put, or would put, a lot of those who aren't genuine asylum seekers into our workforce to then be pulled away when the deportation takes place if they are not genuine asylum seekers. It also creates funding potentially for others looking to travel over on small boats when they may send money back to others to come over. The answer here is what we're doing already and what the Home Secretary and immigration ministers are working hard at day to day, and that's getting the Home Office doing their day jobs again, speeding up the processing so that those who should be in work can be, and those who shouldn't be here are deported. Thank you, Chair.
Thank you, Chair. I too just want to follow up with a few points about perhaps some of the legal issues around what it would mean if you are actually allowing them to work at this point. I mean, on this side of the House, we have concerns already about the Employment's Right Bill with the day one rights that will be accrued. So I wonder about, in this context, how this is going to be actually working. On another level, I wonder about how you'll actually deal with any potential tax that they'll be paying in national insurance numbers until they've actually had their full claims, actually, you know, their asylum claims examined. Quite how will that work? And I see that the clause at 2A talks about so that they can take up a post, which is sort of included within the appendix immigration salary list. I wonder if the member had a bit more detail about what that means or what that entails, because forgive me, I'm not an expert in that area. But I also note that they can't do anything that's self-employed or setting up a business. And I think whilst I can see the principle perhaps of what they were trying to achieve, I think in reality I'm not sure that this drafting would get them anywhere near that, and I have quite a few concerns. Thank you.
Thank you again, Siobhan. I wholeheartedly back the Honourable Member's amendment. It was one I was thinking about posting myself, but the Honourable Gentleman beat me to it. And I think this is a sensible development and amendment, and I think it should be supported by the committee, mainly because it's such an utter waste. We have people with huge skills languishing in hotels, doing practically nothing all day. Now, I go and visit my hotels. We host a number of asylum seekers and refugees in a number of hotels in Perth. And can I just say to the Honourable Member from the Weald of Kent, Scotland more than has its share of the general number of asylum seekers across the United Kingdom. And I don't know where she gets her finger from. Just let me correct her. No, just let me correct her, then she can come back. Scotland hosted 5,086 refugees receiving support from local authorities. That represents 8.3% of the total of asylum seekers. The population of Scotland accounts for something like 8.8% of the total population of the United Kingdom. That is almost our population share, which is actually quite remarkable given the distance Scotland is where most of the asylum seekers come in. And we have a proud record of supporting asylum seekers. Not only do we have our fair share when it comes to hotels, we give free travel to asylum seekers in Scotland, something that we are very proud about. And I'm happy to give way to the Honourable Lady if she wants to come back, but I don't know where she's getting her figures from.
Thank you, Chair, and I thank the Honourable Member for giving way. My figures are from the government release, the data for December 2024. I don't know if he has the further figures there or can break them down, but they are very clearly 1,421 asylum seekers in hotels in Scotland, 4,262 asylum seekers in dispersed accommodation in Scotland, and then 36,658 and 61,448 in the rest, 445 in the rest of the country.
I think myself and the Honourable Lady are going to have to trade these statistics privately, because I've got 5,086 receiving support, and that's from the ONS, is where I've got my figures. So we'll maybe have a conversation with the Honourable... No, I'm not going into this, and I know that we're testing the patience of you, Dean Siobhan. So we'll discuss this privately. We might come back to that at some other day. But what all this also does, as well as being the right thing to do, and given the opportunity for employment, is being able to use the skills that are available to us. The people I've met in some of the hotels in Perth have brought a whole range of skills that would be easily utilised by the community in which they are placed. And it just makes sense just to make sure that we take this forward. Now, the Liberal Democrats put 3 months on all that. I don't know, maybe that's a little bit generous. And I think if I was drafting this particular amendment, I would go for the 6 months that's been generally agreed with all party groups. But I think that what we've done is introduced it as a debating item, and I congratulate the Honourable Gentleman for that. And I think it's something that should be seriously considered. There's been a number of questions again at Home Office about this, and I think there's a number of members, not just from the Liberal Democrats and the Scottish National Party branches, but also from Labour benches. I know we've got quite a compliant set of Labour MPs on this particular committee, but a number of them have raised this in debate and in questions. Yes, of course. And there's one of them.
Can you tell me how many people... Thank you. Can you tell me how many people in Scotland actually work? and how many are employed by the state. Where are these jobs that you're talking about where people are going to be employed? Can't really get people employed just now. You've not been able to do that. You've not provided it. I don't see where the jobs are, but I'm happy to listen to where they're coming from.
I'm grateful to the Honourable General, and of course you wouldn't expect me to have those statistics at my fingertips, so I will, as ministers say, write to him and let him know how many people are in work in Scotland. But can I say to the Honourable Gentleman that we have got the fastest growing employment rates in the whole United Kingdom, something that he and I should be very proud about, of what we've created in our nation. And that he only needs to go and speak to some of the people in care sectors in his constituency. They will tell him they are crying out for available staff to come and place face the holes within their own sector, as it is in the health sector and in a number. Yes, of course.
I think that, you know, thank you very much, Chair. You're talking about care sector, and I take it that takes in palliative care as well. So I've got St Andrew's Hospice in my area. £10 million to run it. £3 million comes from the government. That's an incredible figure and shortfall. You know, I don't understand. So they're talking about leaving people, you know, they're not going to have as much staff as they would normally have. Where does he see all these wonderful figures in care?
I'm not sure of the point the Honourable Gentleman's trying to make. I think he's making something about that there's jobs available for ordinary Scots, I think is the general thrust of his argument and debate. But I would just challenge him to go and speak to people who are actually working and serving in the care sector, people in the NHS. If he's really interested, he could come to my constituency and speak to those in rural sectors, in hospitality and catering, who cannot get the people and the staff to work in their businesses, which is forcing them to close or work in part-time. And that is the reality of the situation. And here we have, sitting in these hotels, people who could do these tasks and function. And not only that, some of them are accountants, some of them are doctors, some of them are economists. The range of skills that are available in each of these hotels is actually quite outstanding. They speak perfectly good English. All of them can do these tasks. And I just think it's just such a waste that they are doing absolutely nothing other than waiting the months and months, possibly even years, for their application to be processed by this government. Now, I know this government have improved on what's been happening with the Conservatives, but it's still a long way to go before we're actually anywhere close to an efficient system where people are having their applications processed readily and quickly. So I support this amendment. I think it's a good one to bring forward, and I really hope that the government listen to this.
Minister, thanks very much. Dame Siobhan, this amendment, new clause 11, really, is about permission to work for asylum seekers in the UK. And the Honourable Member for Woking was saying that this would cut welfare bills, but he needs to be clear that those who are awaiting asylum decisions don't have direct recourse to social security, although we do have to spend money ensuring that they're not destitute while their asylum claims are processed. And clearly, as our honourable friends on this side of the committee have pointed out during this debate, the answer to some of these issues is to recreate a fast, fair and efficient system of dealing with people's asylum claims rather than to have backlogs, particularly also in appeals, which leave people languishing for months and sometimes well over a year awaiting asylum claims. To that end, it didn't help that the Illegal Migration Act was so dysfunctional that it actually banned us from dealing with people's asylum claims and meant that this government inherited a huge backlog of people who were a perma backlog, I think the phrase that we've heard during our debates on this bill. And clearing through that backlog and dealing with the resultant appeals for those who fail is what the government's task is at the moment. But looking through the immediate task, my view, Dame Siobhan, is that the way to deal with this issue is to recreate a fast, fair and efficient asylum system. So that's the first point I want to make in answer to the Honourable Gentleman's new clause 11. The Honourable Member probably knows our current policy does allow asylum seekers to work in the UK if their claim has been outstanding for 12 months. where the delay was caused through no fault of their own. So there is already capacity for those who've been particularly delayed to work, but those permitted to work in this context are restricted to jobs on the immigration salary list. So they can't work at anything, and they're restricted to jobs on the immigration salary list, and that list is based on expert advice from the Independent Migration Advisory Committee, and it usually do with shortages and what the need is in the economy at the time. Policies designed to protect the resident labour market by prioritising access to employment for British citizens and others who are lawfully resident. And that lawful residence is a very important part of the system in this context. And that includes, of course, those who've been granted refugee status, who were given full access to the UK labour market. And this is in line with those seeking to work in the UK under the points-based system. We consider it crucially important to distinguish between those who need protection and those who are seeking to come here to work, who can apply for a work visa under the immigration rules and come here legally. The UK's wider immigration policy would be totally undermined if individuals could bypass the work visa rules by lodging asylum claims in the UK. And the Honourable Gentleman has to understand the nature of that context, because it's very, very important. It is the case that unrestricted access to employment opportunities could act as an incentive for more migrants to choose to come here on small boats, as I think that they are, or irregularly, by whatever means, clandestinely, not legally, without permission to be here, rather than claim asylum in the first safe country they reach. And while pull factors are complex, I'd be the first to admit that, we can't ignore that the perception of access to the UK labour market is amongst the reasons why people take dangerous journeys to the UK. Therefore, opening the UK labour market up to anyone who happens to arrive on the shores, no matter how they arrived, would not help us deal with that issue and would create incentives for more and more people to chance their arm to come here in dangerous ways. I think in addition, removing restrictions to work for asylum seekers could increase the number of unfounded claims for asylum, reducing our capacity to take decisions quickly and support genuine refugees. And I'd like to take this opportunity to make clear that I do acknowledge the concerns that the Honourable Member has talked about with the chaos that we inherited from the party opposite, leading to the backlogs that we are trying to deal with at the moment. We've been clear that individuals who wish to come to the UK must go through safe and legal application routes by applying for the visas that are available, where the reasons for coming to the UK include family or economic considerations. Applications should be made via the relevant route so they can be checked and agreed in the usual lawful way, either the points-based system or reuniting under refugee, family or reunion rules, allowing those who've come here in an irregular fashion to work as if there was no difference between applying for a legal visa and getting proper permission to come before arriving would undermine the entire basis of the rules and create many incentives that I think no one in this committee would like to see created. And I hope, given that explanation and the fact that when there is a delay of 12 months or more, we do allow asylum seekers to work, the Honourable Gentleman will withdraw his new clause.
Oh, Forster.
Thank you, David. I will start with some numbers of best practice elsewhere or examples. Australia, most asylum seekers have the right to work straight away, even though it's temporary. In Canada, they can apply for a work permit whilst their asylum application is being processed. The US allows asylum seekers to work after around 6 months. The EU from June next year will allow, will require member states to let asylum seekers work after 9 months, but some go even further. I know Sweden allow them to work straight away. So we are more out of kilter than the rest of the Western world with having that 1 year restriction, I believe. And I think looking at that is why this amendment, this new clause rather, has been proposed. I would appreciate if the Minister could take away when was the last time we reviewed the 1 year limit and what restrictions we put on them. How often do we review that? I think will be really useful. I don't like people.
Would the woman give way?
I will.
I was listening carefully. Thank you, Chair. I was listening carefully, and there was a light bulb moment which slightly clicked on for me, which was that perhaps the Conservatives did figure out what a deterrent was, which was to try and crash the economy and try and cause our country into such difficulty that actually obliterated a pull factor. But that might be a cruel thing to say. But would he agree with me that actually, where we heard in evidence that there are pull factors with the UK in terms of our language, in terms of our diaspora, in terms of the quality of life here, that actually we have these, but other countries in Europe may not. So that actually, if we were to bring forward this amendment, if we were to make it easier for people who cross the channel illegally to work here, then people may be even more incentivised to come here as compared with other countries.
Thank you. I'm happy to give him a chance to mention Liz Truss and shout at the Conservative economic record. I too take his point, but actually, if the members opposite from the government side like the spirit of this new clause but don't like the detail, why haven't they suggested this new clause should only apply for existing asylum seekers caught up in the backlog rather than those new asylum seekers? I haven't made that distinction. You're implying that there should be that distinction. You are not applying that, obviously. Thank you. Dave Siobhan, you're not applying that. The government are applying that. I haven't used yous for a while, so afraid I did that time. But I think it really highlights what in 2 new clauses' time we'll talk about, which is the government have identified they need to improve the system. I completely agree with you. You have inherited, as a government, a completely broken system. A further new clause from the Liberal Democrats and I would put a legislative framework around that to try to improve that. If the government is so concerned with allowing asylum seekers to work, I hope the government will support that further new clause. Thank you.
Is the member pressing this to a vote? Is everyone content that the new clause to be withdrawn?
Aye.
Aye. New clause 5 withdrawn. We now come to new clause 13, which was debated with new clause 5. Will Forster, do you wish to withdraw or press to a decision?
I'll withdraw.
Is the committee content for new clause 13 to be withdrawn?
Aye.
I thought they were going to stop you there. We now come to new clause 14. I call Will Forster.
Thank you, David. This is a very minor new clause which would require the government to publish a report on the impact of implementing a carer's minimum wage on the level of net migration. As MPs, we want to understand the data and the facts to enable to scrutinise the government. Without this data, I don't think we can do our job properly. And it is as simple as that. Thank you.
Report on impact of carers' minimum wage on net migration.
The question is that new clause 14 be read a second time. Do I see anybody wanting to? Matt Vickers.
Liberal Democrat clause 14 would require the government to publish a report on the impact of implementing a carer's minimum wage on levels of net migration. It requires such publication within 12 months of the passing of this Act. I'll be interested to know what outcome honourable members are seeking to achieve with this clause. What is the proposed minimum wage for carers that the Liberal Democrats would seek to impose? Our care workers deserve fair pay. We're obviously seeing the impact of the national insurance rise on the care sector and the organisations operating therein, who are now struggling to sustain themselves and deliver good jobs and good pay to those care workers they employ. What assessment has been done of the costs of such a minimum wage, and how would the Liberal Democrats seek to ensure that this was fully funded?
Anybody else wish to enter the debate? Have a call on the Minister.
Thank you, Dame Siobhan, and I'm pleased to be able to speak to this to new clause, or speak in the debate on new clause 14. I will just start by saying it wasn't fully clear about what was being suggested in the new clause, and whether it was to commission a review on the impacts of setting a minimum wage either for new entrants or for settled workers in the care sector, and it wasn't fully clear which. But if I just take how we did interpret it, the effect of the amendment would be that the government commission a review into implementing a national minimum wage for workers in the social care sector. Again, unclear whether it's international workers or the whole labour market. It was also unclear, and I think the point made by the opposition as to what the minimum wage for carers was that was being referred to, as there is no sector-based minimum wage standards. The national living wage is currently £11.44 for people aged 21 or over, and it is rising to £12.21 in April. International workers on a health and care visa are currently required to be paid £11.90. If I could just say that I don't believe it is necessary to lay a report in Parliament, given that the government published details on migration on a quarterly basis, which will show the impact of changes on inward migration. And it wouldn't be possible for this data, in the way it's been described, to show the effect of on net migration, as that would also depend on other factors, such as the number of people who choose to leave the UK. This might not be the result of care worker minimum wage requirements, and again it isn't also clear whether it's also looking at settled workers and other workers in the labour market, as well as those who may be coming on health and care visas. It is also worth noting that we have already seen a significant reduction in the number of international care workers being recruited since for just over a year. And this is because employers have also been unable to demonstrate that they have genuine vacancies which would guarantee sufficient hours to meet salary requirements. Most recently published data and statistics show that in the year ending December 2024, the number of international care workers has reduced by 91%. And it's also the case that the work the Home Office is doing with the Department for Health is increasing the role of regional hubs, with £16 million going into this. And those regional hubs play a very important role in supporting workers who may have left one employer, or they may have lost a licence, and being able to find other employment and reduce the dependency on recruiting from abroad, because we're already using those who are here on those visas and wishing to work, along with also continuing to recruit homegrown talent. But I think it's also worth mentioning this point in relation to new clause 14, which perhaps the Liberal Democrats aren't fully aware of, in that we are introducing the first fair pay agreement to the adult social care sector, so that care professionals are recognised and rewarded for the important work that they do. The government will be engaging all those who draw upon care, as well as those that work to provide care and support. And we will also be consulting local authorities, unions and others from across the sector in this. Fair pay agreements will empower worker representatives, employers and others to negotiate pay in terms and conditions in a responsible manner. And the crucial point about this, Dame Siobhan, is that it will help address these long-standing issues that we all know exist in the care sector and affect the sustainability of resource and recruitment and retention into what is an extremely important sector in order to address the workforce crisis and in turn also support the delivery of high quality care. And these fair pay agreements are an important part of the first step towards a national care service. So I do hope that this clarifies the government's position and also why it wouldn't be necessary to lay a report in Parliament and certainly not be making an amendment to this legislation that is about stopping the criminal gangs and the awful trade that they are in. And I do hope that the Honourable Member will seek to withdraw his amendment and engage in this debate in other ways.
Thank you, Dame Siobhan. I'm happy to take the Minister up on that suggestion.
Is everyone content new clause to be withdrawn?
Aye.
New clause by leave withdrawn. We now come to new clause 15. I call Will Forster.
Thank you, Dame Siobhan. This is a new clause that I highlighted in a previous speech. It is to ensure we have a 3-month service standard for asylum casework so that this government can tackle the backlog that they inherited. The new clause would require UK visas and immigration to introduce a 3-month service standard decisions for asylum seekers, both to benefit asylum seekers but also the British taxpayer. The service standard must specify that 98% of initial decisions on all asylum claims should be made before the end of 3 months at the date of the claim. This is something that I think will help the government as they rectify the mess they've inherited. If the government suggests that I've chosen the wrong 3 months and it should be 6 months, I'm very happy to talk about that suggestion. I think setting that stretch target, as this government is doing on several things, like the 1.5 million homes, is appropriate. Thank you.
3-month service standard for asylum casework.
The question is that new clause 15 be read a second time.
Liberal Democrats clause 15 would require UK visas and immigration to reintroduce a 3-month service standard for decisions on asylum cases, meaning that 98% of initial decisions on all asylum claims should be made before the end of 3 months after the date of claim. We agree with the principle that asylum applications should be determined as swiftly as possible, but surely the last draft of amendments and the unfunded proposals to create additional safe and legal routes could only ever increase the queue and the time required to make initial decisions on asylum claims. Do the Liberal Democrats have any proposals on how the government could seek to comply with its proposed 3-month target? The Liberal Democrats do not appear to have any desire to remove those who have entered this country illegally. By deterring rather than inducing people to enter this country illegally, we can reduce those decision times. Is this new clause an attempt to speed up granting of citizenship as per Liberal Democrat new clause 13, rather than speeding up decisions so that we can deport those who have entered this country illegally?
It's worth noting that prior to February 2019 there was a 6-month standard time. That was abandoned by the previous government around the same time that they decided to open the borders. Now what we've been doing, what the ministers have been doing in the Home Office is looking to speed up processing as much as possible. The reason that this amendment would be unhelpful is because often the Home Office are waiting on outside checks to be completed and of course are seeking to speed that up, but that control is limited with such huge backlogs that they're trying to get through. The second point that I think is important is if we legislate for this and an international event occurs, which means some that are being processed have to be put to the back of the queue in order to speed up processing, for example, if another Ukraine situation were to occur, then this would stop that from being able to happen.
Thank you very much, Dame Siobhan. The Honourable Member for Woking has been part of a group, I'm not sure he tabled it, but the amendment that he's spoken to, the new clause would introduce a new service standard to ensure that the majority of initial decisions on asylum claims are made within 3 months of that claim being lodged. I'd like to point out to him that it's good to make initial decisions, but if we're looking at the overall issue of asylum claims and getting people through them in a fast, fair and efficient way, then we also have to think about appeals too. So thinking about the asylum claim from the very start of it to the very end of it, rather than just the Home Office bit, is a really important thing to consider. His amendment only deals with the first part of that, and if you're looking, Dame Siobhan, at a system-wide approach, then one has to look from the beginning to the end rather than just the Home Office's bit, which is the initial decision. And I want to thank him for his amendment and stress that we're in absolute agreement that it's important that our asylum process is fair, efficient, as fast as possible, consistent with fairness and robust. We're committed to ensuring that asylum claims are considered without unnecessary delay. The delay isn't always our fault, but sometimes it has been in the past. We're committed to ensuring that those who need protection are granted as soon as possible so that they can start to integrate and rebuild their lives and contribute to our society in the way that we all want to see happen. So as such, I want to assure him of the important steps that we're already taking to achieve this aim. The government restarted processing thousands of asylum claims which were stuck in the PERMA backlog we inherited when we came into office, and we're clearing those at pace. That is initial decision making, and it's delivering a major uplift also when people fail and have no right to stay here. We're delivering a major uplift in removals of people with no right to be in the UK at 19,000 by the end of January, from July the 4th when we came into office. The government continues to restore order to the immigration system so that every part, border security, case processing, appeals and returns, operates fairly and swiftly. By transforming the asylum system, we will clear the backlog of claims and appeals, and that is work ongoing. We've taken action to speed up asylum processing whilst maintaining the integrity of the system, which includes simplifying guidance, streamlining processes. We've developed existing and new technology to help build on improvements such as digital interviewing and moving away from a paper-based system. We've also changed the law to remove the retrospective application of the Illegal Migration Act 2023, which created the PERMA backlog that we had to deal with when we came into government. This allows decision makers to decide asylum claims from individuals who have arrived in the UK from the 7th of March 2023, with claims to be considered against the existing legislative regime under the Nationality and Borders Act 2022, which was the cause of much of the previous delays. So I hope that he agrees with me that the work we've put in place is now starting to have a real impact, have considerable sympathy with what he's saying in this new clause. But I hope that we'll be able to get to a fast and fair, efficient system with the reforms that we are creating now rather than with this new clause. Will Forster?
Thank you, Dame Siobhan. An opposition member and a minister's not normally meant to agree this much, but I think we do. We probably won't be voting the same way, mind you, but we genuinely do agree. Last year, there was an asylum seeker that was waiting 16 years for a decision on their claim, and at the same time there were 19 people waiting 10 years or more for a decision. That is how broken the system is, and I do not envy the minister's job. I believe this new clause would support the government's work, and I hope members would support it.
Is the member pressing it to a vote? Okay. New clause 15 proposed as on the amendment paper. The question is the clause be read a second time. As many of those people are in favour, say aye. Aye. To the contrary, no. 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 Division. Division no. Lock the doors.
Sarah Ball. No. Jade Botterill. No. Dame Angela Eagle.
No.
Will Forster.
Aye.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
No.
Martin McCluskey.
No.
Seema Malhotra.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
No.
Joe White.
No.
And Pete Wishart.
Yes.
Yeah.
The ayes were 2, the noes were 12. The noes have it, the noes have it. Unlock. We now come to new clause 16. Will Forster.
Thank you, Dame Siobhan. I'm happy to introduce new clause 16, which involves an exemption for NHS workers from immigration skills charge. This new clause would require the Secretary of State to apply for an exemption to the NHS as an employer from having to pay the immigration skills charge when sponsoring skilled employees.
Exemption of NHS workers from immigration skills charge.
The question is new clause 16 be read a second time. Matt Vickers.
Thank you. Liberal Democrat clause 16 would require the Secretary of State to apply an exception to the NHS as an employer from having to pay the immigration skills charge when sponsoring skilled employees. Do the Liberal Democrats not believe that we should be recruiting British workers to work in the NHS before looking to recruit overseas workers? The Liberal Democrats understand that this new clause could result in the NHS looking to recruit more people from overseas rather than from our domestic population, further driving up numbers. And what assessment has been done of the costs of such a scheme, and how would the Liberal Democrats seek to ensure that this was fully funded?
Katie Lamb.
Thank you, Dame Siobhan. The Honourable Member for Woking is moving this amendment, I think, with a view to the role that migrant health and care workers play in UK health services. We are all deeply grateful to our doctors, nurses and care workers. They, of course, do rewarding jobs, but their roles can be difficult and gruelling too. And it is true that currently many people in that workforce are not British, but have come to this country to do that work. We must thank them for helping keep us and our families healthy and cared for. But it is our role here in Westminster to look at the whole picture, informed but not led by individual cases. And when we look at that whole picture, we can see that the volumes for the health and social care visa are eye-watering. Since 2021, more people have come to this country under the health and social care route than live in the city of Manchester, well over 500,000, of whom many are dependents. And yes, that's because these jobs are tough, but it is fundamentally because they are underpaid. To quote the Independent Migration Advisory Committee, the MAC, the underlying cause of these workforce difficulties is the underfunding of the social care sector. Immigration cannot solve these workforce issues alone. Underpaying health and social care professionals is financially self-defeating because the money the government saves in the short term by underpaying workers is dwarfed in the medium and long term by the costs to the state. As we have already discussed this afternoon, and as the Minister opposite has heard me say now in several different settings, after 5 years, a person who has come to this country on a health and social care visa can apply for indefinite leave to remain, or ILR. If they get it, and 95% of ILR applicants are successful, they will qualify for welfare, for social housing, surcharge-free NHS care, everything. All of that must be paid for, and the cost is far greater than those on these sorts of salaries will ever pay in tax, and far more than they are saving the state in their artificially low wages. These individual workers are also at risk of exploitation. This is a result of the poor pay and conditions across the sector, which have been allowed to endure through bringing in workers from abroad who are willing to accept them as the price of coming to Britain. The next related issue with this visa is the degree to which it is abused. Again, I quote the MAC, who described misuse of this visa as a significant problem and greater than in other immigration routes. All this raises massive concerns about the safety of the patients and the vulnerable people the system is charged with caring for. The rules around the health and social care visa need to be tightened further, not loosened through an exemption from the immigration skills charge, and actually enforced. This is for the good of those healthcare workers themselves, but also, which would be the primary concern of those of us here, for the good of their patients and the good of this country. Exempting NHS workers from the immigration skills charge, or indeed doing anything that makes it relatively cheaper still to hire migrant workers, will make the fundamental problem in the labour market in the health sector even worse.
Pete Wishart.
Again, Dame Siobhan, and it seems to be a bit of a Lib Dem fest this afternoon with the honourable gentleman's new clauses, and can I say to him, there's nothing wrong with that, and I very much approve of this new clause that the honourable gentleman brings forward. And I think I have to say to the honourable member for the Weald of Kent again, and I don't like rebuking her because it's not the sort of member of Parliament that I am, Dame Siobhan, as you will know, but there's so many people come through the health and social care route because there is real need within the whole of this system. We need people to come and make sure that they have those jobs. I challenge her to go and visit her own NHS establishments to find out some of the real difficulties that so many health professional managers have in securing the staff and the workforce they require. This is a practical suggestion. It deals with a real issue in our immigration system, and it's so unfair that people who are coming in to do some of the most demanding, lowest paid jobs in the UK are forced to pay this charge. So it's a... yes, of course.
Thank you, Chair. I thank the honourable member for giving way. I don't disagree with him at all about the problems in the sector. The point I was making is that the fundamental reason for those is that those roles are underpaid.
Well, we know that that's the reason that there's so few people within the general community who she would probably class as British born who are prepared to do some of these jobs. We are dependent upon people coming into our shores to do these jobs, and our health service would fall apart if somehow they all decided that they would depart and leave. We are dependent upon this. It's unfair that they have to have this extra and excessive charge, and I think it's a reasonably good amendment, and I really hope the government start to look at this, because it's one of the few practical new clauses that would actually make a significant improvement to the situation that we're debating today.
Can I see any further? Oh, apart from the Minister, no? Can I call the Minister?
Thank you, Dame Siobhan, and I do want to thank the Honourable Member for working for speaking to this new clause 16, which, as we've debated, the purpose of this is to exempt the NHS from paying the immigration skills charge when recruiting skilled workers. I recognise that the intention of this amendment is to protect the NHS and reduce the cost of recruiting those vital health and care professionals who we all know do a fantastic job and a very important job for all of our constituents and our families, looking after the well-being of people across the UK. It is, however, worth recognising that this would run contrary to the government's position that we should be reducing our reliance on international workers in all sectors of the UK, and that does include the NHS. The clue to what this is for and why we have the immigration skills charge is skills. And removing the immigration skills charge would send the wrong message. It would be removing an important tool in encouraging employers to look first at the domestic labour market and what more can be done to train and improve the skills of those already in the UK, rather than simply looking outside of the UK and continuing our reliance on overseas trained workers to support our public services. So I do hope that in light of what the immigration skills charge is there for, and how it is there to be helping support the development of skills, and in order to therefore support the growth of our skills, talent here in the UK, that he will reconsider this new clause and withdraw it today.
Well, of course.
Thank you, James Siobhan. I'll start with sort of what I would describe as the brass neck on the Conservatives for breaking the NHS, breaking the immigration system, breaking the social care system, and then criticising an amendment for trying to tackle these problems that, which I find extraordinary. We should be reducing our reliance on foreign labour to support the workforce in the UK, including the NHS. But until we as a country have done that, I don't believe we should be making the NHS pay the immigration surcharge, and that is the purpose of the new clause. And I'd hope some members would support me. Dame Siobhan.
Does the member wish to press this amendment? New clause 16 proposed as on the amendment paper. The question is that the clause be read a second time. As many of that opinion say aye.
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 To the contrary, no.
No.
No. Division. Lock the doors.
Sarah Ball?
No.
Jade Botterill?
No.
Dame Angela Eagle?
No.
Will Forster?
Aye.
Becky Gittins?
No.
Tom Hayes?
No.
Katie Lamb?
No.
Martin McCluskey?
No.
Seema Malhotra?
No.
Kenneth Stevenson?
No.
Mike Tapp?
No.
Matt Vickers?
No.
Joe White?
No.
And Pete Wishart?
The ayes were 2, the noes were 12, the noes have it, unlock. We now come to new clause 18, with which it will be convenient to debate new clause 19. I call Will Forster.
Thank you, Dame Siobhan. I will briefly introduce both of these. Fundamentally, the Liberal Democrats and I are concerned that we need to understand the impact of our immigration laws on those that are victims of human trafficking, those that are victims of modern slavery. New clause 18 would require the Secretary of State to introduce legislation which incorporates the Council of Europe Convention on Action Against Trafficking in Human Beings into UK law and report compliance with the Convention. And new clause 19 would prevent a public authority in determining whether a person is a victim of slavery or human trafficking from sharing immigration with immigration authorities or other public authorities that might result in the deportation or persecution for an immigration offence. I do hope these amendments are taken in the spirit they are intended. If they do fail, which based on my last hour I think they might, but I would hope both ministers and their officials take the spirit that these have been tabled to fully work with their teams to ensure that we see through our immigration laws to make sure that no vulnerable person that has been a victim of human trafficking, etc., falls through the cracks. Thank you.
Council of Europe Convention on Action Against Trafficking in Human Beings.
The question is that new clause 18 be read a second time. Matt Vickery.
Yep. The Liberal Democrat new clause 18 would require the Secretary of State to introduce legislation which incorporates the Council of Europe Convention on Action Against Trafficking in Human Beings into UK law and report on compliance with the Convention. The Liberal Democrat new clause 19 would prevent a public authority, when determining whether a person is a victim of slavery or human trafficking, from sharing information with immigration authorities and other public authorities that might result in deportation or prosecution for an immigration offence. We've seen the abuse of human rights legislation, for example, by criminals who want to remain in the UK. For example, an Albanian criminal who was allowed to stay in Britain partly because his son will not eat foreign chicken nuggets. The judge in the case allowed the father's appeal against deportation as a breach of his right to family life under the ECHR. Foreign criminals pose a danger to British citizens and must be removed, but so often this is frustrated by spurious legal claims. The human rights of our own citizens to be protected from the criminals are routinely ignored. How do the Liberal Democrats plan to stop abuse of these clauses by people who know their asylum claim is likely to be rejected, for example?
Can I see Pete Wishart?
Just very briefly, Dame Siobhan, I rise in support of the Honourable Member's amendment, particularly Amendment 18. I think there's been a number of references to ECAT throughout the whole of our proceedings, looking at the various new clauses and amendments that we're debating. And I think what this would do would be give clarity and to ensure that we are properly engaged and rolled into all the provisions within ECAT. It's an important piece of legislation that's there to ensure that those that are caught up in human trafficking are protected, and every government does everything they possibly can to ensure that they are going to be cared for and looked after. So I fully support the Honourable Gentleman's amendment, new clause.
Anybody else wish to contribute to debate? Can I call the Minister?
Thank you very much, Dame Siobhan. And I think that everybody in this committee, and I'm being very generous, thinks that it's important to protect the victims of modern slavery, and we have legislation in our country to try to ensure that that happens. I think we also have signed the Europe Convention against the Trafficking of Human Beings, and this country complies with the obligations under it. New Clause 18 wants this convention to be incorporated into UK law, but UK compliance is already achieved by a combination of measures contained in domestic legislation such as the Modern Slavery Act 2015 and the Nationality and Borders Act 2022. The criminal justice system and the processes set out in the modern slavery statutory guidance for identifying and supporting victims of slavery and trafficking. Implementation and compliance with these obligations doesn't require full incorporation into UK law, and therefore this amendment is not required. It won't really add a lot. And new Clause 19, the Modern Slavery Act 2015, provides certain named public bodies in England and Wales with a statutory duty to notify the Secretary of State when that body has reasonable grounds to believe that a person may be a victim of slavery or human trafficking. The information provided for that notification enables the UK to fulfil its obligations to identify and support victims of slavery and trafficking. The duty to notify is discharged for adults by making a referral into the National Referral Mechanism, where the adult consents to enter the mechanism, or by completing an anonymous entry to that mechanism on the digital system where the adult does not consent. The information provided via the digital system is used to build a better picture of modern slavery in England and Wales and helps to improve the law enforcement response. So it's important that that information is collected. The information doesn't include that which identifies the person either by itself or in combination with other information, unless the person consents to the inclusion of the information. So that information can be put in there anonymously. Child victims don't need to consent to enter the National Referral Mechanism. As such, the National Referral Mechanism discharges the duty to notify. If a person is identified as a potential victim of modern slavery or trafficking in the National Referral Mechanism, then they are eligible for a recovery period during which they're protected from removal from the UK if they're a foreign national and are eligible for support, unless disqualified on the grounds of public order or bad faith. So bad faith is lying about your circumstances. Public order is if a particular individual may be a danger to society. And we've had some discussion about this with respect to Section 29 of the Illegal Migration Act, which retained, this government has decided to retain but has not yet commenced, and Sector 63, I think, of the national, the NABA. So I think the other thing to say is that when we came into government, the national referral mechanism decision-making process was in disarray with a huge backlog. We have made it clear and created a circumstance where 200 more caseworkers were allocated to deal with the backlog, and there's a great deal of progress has been made in getting that backlog down, very, very good progress, and obviously my honourable friend, the Minister for Safeguarding, has got that, getting the national referral mechanism back on track as one of the things that she's particularly concentrating on in the battle against modern slavery. So I hope with those responses that the honourable gentleman will withdraw his clauses.
Will Forster? Is everyone content for the new clause to be withdrawn? Aye. New clause by Lee withdrawn. We now come to clause 19, which has just been debated. Will Forster to move formally. Do you want to withdraw or press to a decision?
Withdraw.
Is the committee content for new clause 19 to be withdrawn?
Aye.
We now come to new clause 20. I call Will Forster.
Thank you, Dame Siobhan. This is a very comprehensive new clause, and I think I'm really tempted to be very brief in my introduction to it. My Liberal Democrat colleagues would like to suggest a humanitarian travel permit to counter the gangs that the government is seeking to attack and undermine via this bill. But we do need to support those that genuinely need to travel here safely. And this is seen as an appropriate way forward. This it's very long and comprehensive, and I assume fellow colleagues might want to ask a lot of questions, or they might consider they want to take apart this new clause. But it's a genuine suggestion to how we undermine the gangs and encourage people to come here safely.
Humanitarian travel permit.
The question is that new clause 20 be read a second time. Do I see anybody who wants to join the debate?
The Liberal Democrats have put forward new clause 20 to introduce a so-called humanitarian travel permit. We've previously drawn up schemes such as the Homes for Ukraine scheme or the Ukrainian Family Scheme for families seeking refuge from the war. We do not need a specific permit which would see people from across the world trying to use to come to the UK. We do not support this measure.
Anybody wish to enter the debate? I call the Minister.
Thank you, Dame Siobhan. I'll just keep my remarks quite brief, because I think there is some overlap with some of the previous debate that we had in relation to safe and legal routes. This new clause proposes a new humanitarian travel permit. As we've mentioned before, the UK has a strong history of protecting those fleeing war and persecution around the world, and I talked about the UK resettlement scheme that we run in partnership with the UNHCR. And it is the case that when that processing is done and refugees are accepted and they are assessed by independently by the UNHCR, and they may then be allocated to the UK and the arrangements under that scheme, then it is then for the UK to provide the visas to those in advance of them travelling to the UK that enables them to come here safely. We did discuss previously as well about why there is no provision in the immigration rules for someone to be allowed to travel to the UK to seek asylum, which I think is part of what this would seek to do. And there are risks with this as well, in that those in that whilst we might seek and be sympathetic to having the international systems that we talked about to support those who are fleeing very difficult and dangerous situations for themselves, it would be very difficult to consider protection claims from large numbers of individuals overseas who might like to come to the UK. And what is the case, as part of our ways in which we run this, we seek to have a system that works internationally, is that those who need international protection should claim asylum in the first safe country that they reach. And that is the fastest route to safety. I mean, it is also important to be clear, the debate around safe and legal routes and our humanitarian routes alongside other routes through which people come to the country, work, family, study and so on. These are always routes that we keep under debate, and the upcoming immigration white paper, which will be setting out proposals in our response to how we bring our immigration system back under some control and ensure that it is fair, that it is well managed, that it is controlled after the utter chaos in all respects of the immigration system, regular and irregular routes that we have seen happen under the previous administration. That it does take a whole system approach and a look at how the immigration system is working as a whole, and to have that as part of an important debate led by evidence and contributing through data to more evidence for the future. And it is also the reason why, in relation to I think some of the underlying drivers of this new clause, that we are determined to restore order to the asylum system, so that it operates swiftly, firmly and fairly, and ensures that rules are properly enforced. Thank you.
Will Forster.
Thank you, Dame Siobhan. Firstly, the MP for Stockton West, that's my geography failing me, highlighted that actually this scheme is not dissimilar to ones that his former government introduced for Ukrainians and for those from Afghanistan, which I found an interesting comparison from him. If it's appropriate for some specific countries, why would it not be appropriate to have on the legal shelf for if we need it? This world is now more dangerous than ever before. There's more... I will.
Thank you, gentleman, for giving way. Just going back to what the Minister brought up, does he acknowledge that the UNHCR schemes do precisely that?
I acknowledge they try to do exactly that, but I don't think they're working. The exhibit why they're not working is the amount of small boats we're having, the amount of people fleeing conflict. I don't think those rules meet the current framework that we're working in the UK and the world, hence this suggestion. I will be brief, so I'm mindful of time. I hope some members would support this new clause, which would be a good legal tool for attacking the gangs and protecting vulnerable people as they flee their homes in conflict.
So members are pressing it to a vote. Okay. New clause 20 proposed is on the amendment paper. The question is the clause be read a second time. As many are of that opinion, say aye. Aye. To contrary, no. 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 Division. Lock the doors.
Okay, Sarah Ball?
No.
Jade Botterill?
No.
Dame Angela Egon?
No.
Will Forster?
Aye.
Becky Gittins?
No.
Tom Hayes?
No.
Katie Lamb?
No.
Martin McCluskey?
No.
Seema Malhotra?
No.
Kenneth Stevenson?
No.
Mike Tapp?
No.
Matt Vickers?
No.
Joe White?
No.
And Pete Wishart?
The ayes were 2, the noes were 12, so the noes have it, unlock. We now come to new clause 21, which will be debated with Amendment 1. Does Matt Vickers want to withdraw or press to a decision?
Yeah, yes, please. We wish to divide, yeah.
Okay, so it's moved formally.
Yeah.
So, functions of the Commander in relation to sea crossings to the United Kingdom.
The question is that new clause 21 be read a second time. As many are of that opinion, say aye.
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 To the contrary, no.
No.
Division. Lock the doors.
Okay, Sarah Ball.
Aye.
Jay Potterill.
No.
Dame Angela Eagle.
No.
Will Forster.
Abstain.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Seema Malhotra.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Yes.
No, go on.
Joe White.
No.
And Pete Wishart.
The ayes were 3 and the noes were 9. The noes have it, unlock. We now come to new clause 22, which has already been debated with clause 23 and stand part. Matt Vickers, do you want to withdraw or press to a decision?
We wish to press to a division.
Okay. The question is that new clause 22 be read a second time. As many are of that opinion, say aye.
Aye.
Of the contrary, no.
No.
No. Division. No. Lock the doors. The new doorkeeper's getting next exercise.
Get that UB40 out.
Okay. Sarah Ball.
Aye.
Jade Potterill.
No.
Dame Angela Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Seema Malhotra.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
And Pete Wishart.
No.
The ayes were 3, the noes were 11. The noes have it, unlock. We now come to new clause 23, which has already been debated with clause 27 stand part. Mr Vickers, do you want to withdraw or press to a decision?
We wish to withdraw.
Okay. Is the amendment agreed to be withdrawn?
Aye.
You know what I mean?
Yeah.
By leave withdrawn.
Beg to move that the committee, for the consideration of the bill, be now adjourned.
It's been a long day. The question is that further consideration of the bill be now adjourned. As many are of that opinion, say aye. Aye. Of the contrary, no. I think the ayes have it, May I thank everybody for your cooperation.
Thank you.
Committee Room